Hi guys, my name is Karabasi Tole and I'm a student from the University of Witwatersrand studying accounting science. So in today's video, I'm going to be discussing a memo of a question paper that I made for test 1 commercial law. If you don't have the past paper, I'll try to put the questions right for you guys. And if you do have the question paper, then good for you. In this video, I'm going to be discussing the answers for question 1 to 11 and then questions 12 all the way to 36 are actually given in the question paper under the memo section. If you haven't subscribed, please do so. These videos really take time, they take effort. So please subscribe, click the subscribe button. It motivates me to keep on doing what I'm doing and keep on helping. So let's get right into it. I'm going to be discussing these questions, but I must say that this is the first video I'm doing on law and it moved me out of my comfort zone. So please do forgive any mistakes I might make. Also, please, I do not know how to pronounce these Latin words. So I know how to identify them, but not pronounce them. So please bear with me. The first question says, which one of the following is regarded in the South African law as a source of Roman Dutch law? So I don't know if you guys know, but the South African law adapts like its laws and its principles a lot from the Roman Dutch law as well as the English law. And this dates back to how things were done in the apartheid era and then post-apartheid, right? Some of the laws were reviewed, the Bill of Rights, the Constitution, they all came in hand. However, we adapt our law from the Roman Dutch law, so as well as partly from the English law. Actually, a small segment from the English law. Most of our laws are actually adapted from Roman Dutch law. So the question is saying which one of the following is regarded in the South African law as a source of Roman Dutch law. So when you're given a question like this, you need to look at the options and ask yourself, is this part of Roman Dutch law or is it not? So the first one says the law of the 12 tables. The law of the 12 tables is a law from the Roman Dutch law. However, it is an unwritten law, right? So we won't consider it. The second one says institutions. So the second option and the third option are not laws, right? So there's something else, they're just random words. The fourth one is the answer, and I don't know how to pronounce this. This is the answer. Yes. So I suggest that you guys go and do further research on these laws. For example, if you want to know what the law of the 12 tables is, just go and research so that if a question like this comes, you know other Roman Dutch laws, right? The second one says, which one of the following is a principle that cannot be associated with the doctrine of stare decisis? So stare decisis is a doctrine that says that a court is bound by its past decisions, and any court that falls under that court is also bound by the decisions of a court higher than that, right? So for example, if a high court in Johannesburg makes a decision, that high court is bound by its decision even in cases in the future. And any court such as the magistrate court, because it is lower than the higher court, it will be bound by those decisions that are made by the high court. So I'm not sure if you guys understand. However, if a high court in Gauteng, right, takes, or a high court in, how many high courts do we have? I think we have 2, yeah. But let's just say 2 high courts, let's just say high court in Joburg takes a decision, right? That decision by the high courts will not bind other high courts, right? Outside of that province, right? So all the high courts in Gauteng will be bound by the decision of that one court in Gauteng. However, a high court in KZN will not be bound by the decisions of a high court in Gauteng. I'm not sure if you guys understand. But yeah, if a high court in Gauteng takes a decision, all high courts in Gauteng will be bound by that decisions. However, courts outside of Gauteng will not be bound by those decisions. So that's the doctrine of stare decisis. I'm so proud of myself for saying this word. Okay, so the first one says, remember, we're looking for a principle that cannot be associated with what I just explained. So it says a high court is bound by its own decisions unless overruled by a superior court. This is true. So if a high court takes a decision, as I said, courts in those area and courts below it will be bound by those decisions. However, if a constitutional court or a superior appeals court goes against that decision, then there is no judicial precedent. So yeah, a high court is bound by the decisions of a court of concurrent status within its own area of judice of its own judice your jurisdiction. Oh my god. Okay, this is false. This is true, I mean, because it is bound by the, like, if a high court in Gauteng takes that decision, all courts in Gauteng will be bound by that decision. So a high court, depending on how it is constituted, is bound by a decision of the Supreme Appeals Court. That is false, because I'm sorry, I don't know why I'm getting distracted, but I'm just looking at my options based on how it is constituted. Or a high court, depending on how it is. Okay, so the answer for this one is number 3, which says a high court, depending on how it is constituted, is bound by a decision of the Supreme Court of Appeal. So this is false, because it is not based on how it is constituted. Any decision from a superior court binds it, like, regardless of how it is constituted, regardless of how many judges it has, regardless of how big the court is. If like a higher court than you makes a decision, a lower court is bound by that decision. So for number 2, the answer is 3. For number 3, it says, in the case of Van Brenda and others versus Jacobs and others, AD 330, consider the following. The court will acknowledge the validity of this community's customs if it can, amongst other things, indicate that the practice that prevented fishermen from casting their fish nets in front of other fishermen who cast theirs first has, number 1, A, has existed for a long time. So we're talking about customs rights. So remember, there's requirements for a custom to be recognized by the courts. So the first one says has existed for a long time. Tick. So for a custom to be recognized, it must have existed for a long time in that particular area. Secondly, has been put in writing. No, that's false. Does not need to be put in writing. Will encourage the breeding of whales. Whales have nothing to do with this. It is certain and clear. So yes, those 2 ones are requirements for a custom to be recognized by the courts. Okay. So the answer is number 3, which is A and D. Number 4 says, which one of the following statements is correct? In Van Dijk, I'm so sorry for these pronunciations, versus South African Railways and Harbours, 1956, Volume 4, South African Publications, 410, which is the page number, W Western Cape Courts. Number 1, South African Railways is the appellant. Van Dijk is the defendant. 1556 is the year in which the case was reported. Number 3 is the correct one. So there's something that I want you guys to understand, and I want to refer to the notes that I made. So for this one, the correct answer is number 3. 1956 is the year in which the case was reported. So I want to teach you guys how to read your case laws, right? So this is how you read your case laws. I hope you guys can see this whole thing, right? So reading a case law name. So this Van Dijk versus South African Railways and Harbours are our litigants' names. These are the people. This is a civil case because there's no state versus a person's name. It's two civils, right, who are fighting against each other. So the first name in any civil case is the plaintiff, also called an appellant. Is the person who brought the case, right? It's the person who wants to sue the other person. The next, or the second name, is the defendant. This is the person with whom the suit is brought, right? So yes. However, on an appeals, whenever there's an appeals, the names will switch, because if you're having an appeal, it means you are the one bringing the case, right? You're no longer the defendant. You're appealing the decision of the courts. So meaning that the names will need to swap around. You become the appellant, and then the other one becomes the defendant. So yeah, this year is the year in which it was published. The number that you see on a bracket is the volume number of the case, right? So the SA, sometimes there are only two things they can write here after the volume number. It's SA or all SAs. So this is the publication. This is the publication label. This is the publication of your case laws. Okay, guys, I'm tired. Yeah. And then the next thing that comes is the page number, right? And then W is like an abbreviation for the courts. I think this is the Western Cape High Courts, if I'm not mistaken. So these are the other court abbreviations that you can have. You can have CC for Constitutional Courts, C, Cape High Court, N, KwaZulu-Natal High Courts, A, I don't know what this is, Division, SCA, Supreme Court of Appeal. So that's how you read your names, right? So in this question, Van Dijk, I hope I'm pronouncing it right, is actually the appellant. He or she is the plaintiff, right? And then the next name, which is South African Railway and Harbours, is the defendant. So 1956 is the year in which it was published. 4 is the volume number. SA is where the publication of the laws is. 410 is the page number. W is the abbreviation of your courts, right? So the right answer is number 3. So that's what I wanted to bring to your attention. This is moving so slower than I thought. But number 5, it says indicate the incorrect statement. The Supreme Court of Appeal, which usually sits in Bloemfontein, has unlimited jurisdiction to hear appeals in civil and criminal procedures. True. A case relating to the interpretation of a will may be heard by a magistrate's court. False. Remember, we have like 2 types of courts. We have superior courts and we have minor courts. Superior courts deal with things that like are really doesn't sin. And how do I translate this to English? Like things that, yes, translate for me in the comments section. I mean, like they discuss serious matters such as murder, such as rape, such as wills. And then the minor courts discuss things such as fines, fines for tickets for like when you park your car incorrectly, those kind of issues, like small and minor issues. So a case such as like a case involving a will be discussed in higher courts and not smaller courts. So that is the false answer. Number 6 says, which one of the following legal systems is the basis of the South African legal system? It's obviously the Roman Dutch law. It's not only the Dutch law, it's not only the Roman law, it's not only the English law, but it's the Roman Dutch law, right? So the number is number 4. Number 6, question number 6, the answer for it is number 4. Question 7, which one of the following is not an authoritative source of South African law? We have South African case law, legislation, English case law, the Constitution of the Republic of South Africa, and textbooks. So textbooks are not an authoritative source of law. They are a secondary source of law. They are persuasive in nature. Which one of the following statements regarding the Curio Advisory Vault doctrine is correct? So the Curio Advisory Vault means that the court is open for changes in its judgment. So a higher court, it is open for a higher court to give a different judgment to its case, meaning that you can actually take it for appeal, right? So the first question says, a higher court, whether it is a full bench consisting of 3 judges, a bench of 2, or of only 1, is bound by the decisions of the Supreme Court of Appeal. Do you remember what this is? Stare decisis. Yes. 1 high court is not bound to... I'm so proud of myself for this. Yo! Oh my god. I'm so much out of my comfort zone. I don't even want to lie. Sorry for the mistakes I keep on making. Number 2 says, 1 high court is not bound to follow the decisions of a high court from another area of jurisdiction. I talked about this. This is stare decisis. Within the area of jurisdiction of 1 high court, a bench of 2 judges is bound by the decision of the full bench of 2 judges. I spoke about this. The court needs further assistance on the case from a higher court and is open to review its judgment. So that is what Curio Advisory Vault doctrine means. So just look at the term advisory. This is how it's written, because you guys can't see what I'm reading. So yeah, on number 8. It is written as Curia Advisory know I'm reading this wrong, miserably wrong. But anyways, we keep moving. Question 9. Which one of the following is not a requirement for a custom to be recognized as a legal rule? It must have existed for a long time. That is true. That is required. It must be generally recognized and observed by the community. That is true. The content therefore must be certain and clear. That is true. A court must have recognized the custom as a legal rule. That is false. For something to be recognized as a custom, the court it's not a requirement for the court to have agreed to it. However, if in order for when you go to a court, you need to prove that it's a custom, and these are the requirements that you follow. And if the court agrees with you that it's a custom, you don't have to prove it in the future. However, that doesn't mean that for the community to think it's a custom, the court must have agreed, right? So yeah, that's what they mean. But once the court agrees, you don't have to prove it in other case laws that it's a custom. In other court cases, I mean. Almost there, guys. Question 10. Soon after the death of multimillionaire Elon Musk, dispute rises regarding the validity and interpretation of his will. Which one of the following courts should be approached to adjudicate the matter? A magistrate court, false. That is a minor court. A small claims court, false. That is a minor court. The constitutional courts, you only go to the constitutional court after you have gone where? To the Supreme Appeals Court, a high court. Yes, because remember, you first need to start at the high courts, right? You need to start at the high. Okay, so you will start at, so for cases such as wills, you go to high courts, right? You go to superior courts, right? And which superior courts do we have? We have high courts, right, at the lowest level. Then we have superior courts of appeals, and then we have the constitutional courts. So you will first start at the high court, and if you're not satisfied, you will go to the superior court of appeal. If you are still not satisfied, only then do you go to the constitutional court. You don't just go to the constitutional court. You first start with the high courts, then the Supreme Court of Appeal, then the high courts. Question 11 says, which one of the following officers is responsible for the issue of process, the enrollment of cases, the maintenance of records, and the issuing of orders of the High Court? It is the, what do we call it? The sheriff. Yes, it is the sheriff. So I have notes on this too, on who is responsible. So we have these people. I'm not sure if you guys can see, but okay, let me just make sure you guys can see what I wrote. Okay. So we have court employees, right? Attorneys and advocates, they go to courts. Prosecutors, these are lawyers that represent the state on criminal cases. And then we have the registrar or the clerks of the court, and they handle the documents of the case. Then we have sheriffs, which are responsible for delivering legal documents to people.